Good afternoon, everyone. I know we're a minute or so before noon, but I thought I'd open up this webinar. I'll wait another minute or so for the final attendees to join, and then we'll get started talking about the top 10 mistakes executors make and how to avoid them. Okay, everyone. Well, it looks like most attendees are here, so let's get started. Good afternoon, everyone. Thank you for joining us today for top 10 mistakes executors make, and of course, how to avoid them. My name is Whitney O'Reilly. I'm an attorney here at Cohen Seglias. I'm here in the Philadelphia office and a member of the firm's Wealth Preservation and Business Transactional Group. For almost a decade now, I've been doing estate planning, that's drafting your will and power of attorney documents, business succession planning, how to transfer your business to the next generation, estate administration, that's the process of transferring your assets after you've passed away, and general trust work. So if you have any questions during this program, please ask them in the question section of this GoToWebinar panel. We'll address the questions as they come in. Please do feel free to ask questions. I certainly love questions through this. It helps the time go by a little bit quicker, and it helps answer your specific questions. Additionally, a copy of these slides is available in the handout section of the GoToWebinar panel. Okay, so let's get started. In the words of Benjamin Franklin, in this world, nothing can be certain but death and taxes. So let's talk a little bit about death and taxes. First, we're talking about the top 10 mistakes executors make and how to avoid them. But what we need to find out first is, what is an executor? Who is this person, right? It's a person or institution, and it's often called other things in other states. So we've got executor here in Pennsylvania. We also have the feminine version, executrix, although that's going out of fashion a little bit, and we tend to use executor for both the masculine and feminine roles. But in other states, it can be known as a personal representative. If someone doesn't have a will, instead of being called an executor, they'd be called an administrator. But they're the person that's appointed by someone who's known as the testator. That's the person who has died. They've named them in their last will and testament. Now remember, a will is the document that says what happens with your things when you're not here anymore and who's in charge of them, right? This role can also be known as a trustee if someone has a revocable trust. And this whole process is known as an estate or trust administration, right? So over the years, I've seen many executors fall into this trap where they think things are going to be really, really easy, right? And that carries its own dangers. I've also seen executors terrified of the millions of things they have to do. So it's really important to let your executor know that they're named in your document, in your will, where your will is located, and any other pertinent information you'd like to share with them. Myself, I'm often the estate attorney for whole families, and that's really great because the family has the comfort of me not only knowing them, but the people they're leaving their inheritance to and the people they're putting in charge of things. So let's talk about most common mistake number one that executors make, and that's probating the wrong document. So this failure to probate the correct document, well, first we need to figure out, what does probate mean, right? Now, I know a lot of people, when you hear the word probate, you naturally sort of panic because we've all read and heard so much about how we should avoid probate at all costs. Well, in Pennsylvania, that's not really the case. You can relax a little bit because in Pennsylvania, unlike other states, it's not that bad. Probate can be long and difficult and expensive, but in Pennsylvania, that's not the case. Most of my estates never go through the full court-supervised probate process. And that reason is because many probate requirements can be opted out of. In addition, and unfortunately, Pennsylvania is a high tax state, but it's actually a low probate fee state. I was working on an estate administration of a few $1 million a couple of weeks ago, and the probate fees were maybe $2,000, so pretty low probate fees. So when I'm talking about probate, I can talk about the whole probate process, but right now I'm just talking about probating the will. So the first thing that the executor does after someone passes away is find the last will and testament and go to the Register of Wills of the county where the person died, and they have to get sworn in. The registrar is going to check to see if the will is authentic, and they're going to make sure that you're the executor, and you're going to take an oath, and you're going to promise to do what you're supposed to do by law for the estate. There's normally a small probate fee. We've just talked about how minimal it is here. And this is a word of wisdom right here. You really want a well-drafted will, so your executor has all the powers to opt in and out of probate requirements and handle any matter that arises in your estate without having to necessarily involve the court system. So one of the first duties an executor has to do before they go to probate this will is make sure they've got the right will or trust, right? Many times people stop searching too soon, and they find an old will and later find out that it's been updated. So as an executor, it's really your duty to identify the most recent document and to make sure that it's not been revoked. So as an executor, what you can do to avoid probating the wrong document is check the house, check the safe deposit box, check with the drafting counsel to make sure you've got the most recent document. It's really important because if you start down this wrong path, you may have to spend thousands of dollars fixing a problem that may not have existed. This same advice goes for if you have a revocable living trust. And I talked about it right in the beginning, but it's important to know that just because you have the correct will doesn't mean the estate needs to be probated. Sometimes we don't actually need to probate an estate administration. So you want to make sure that you talk to your legal counsel first before you start down the path of probating any document. So now we're going to move on to the second most common mistake that executors make, and that is making an early distribution without protecting yourself from liability for that distribution. So everyone listening here who are executors or expect to be executors or trustee, put a big star around this one, because this could really cost you money. You can be personally liable for this. When you're an executor or trustee, many times you just think once you get the money, you should hand it out and you don't worry about probate or court taxes, but that's wrong. If you make a distribution before the end of the estate administration, these are called at-risk distributions, and you are personally at risk. So let me give you an example. So my Uncle John has passed away. I gather all his assets. I sell his house. I have about $400,000. Me and my brother are the beneficiaries. I give him $200,000. I keep $200,000. But then many months later, I find out there's this state death tax called the inheritance tax. And it was a probate asset, this house, so I owe probate fees. So now I go back to my brother, and I ask him for about $40,000 back. And he says, I can't. I've already spent. You're now liable to the state and to all creditors of the estate, and it's your responsibility to get that money back from your brother. So if you do make an at-risk distribution, you've got to make sure you've got a document where the person receiving the money promises to pay it back. So we call this document a refunding agreement, or an early receipt, release, and indemnity agreement, or even a preliminary family settlement agreement. The end of the estate administration, you can make distributions without going to court. We're going to talk about that a little bit later in this presentation, but there's a big difference between having the right to get the money back and getting it back. So you've got to be really careful when you hand out money in an estate administration, right? If you do want to make an early distribution, also make sure that you've got enough held back so that the possibility of you ever having to take money back from them or ask siblings or other family members for money back, we want to make sure that we've got that in the coffers before we start handing out money. And if we do hand out money, if we do make these early distributions, let's make sure that we've got some agreement in place so that the beneficiary signs off that they're willing to give some of that money back if we need it in order to pay expenses. So first we talked about probating the correct document. Now we're talking about giving money out immediately and how we can get into trouble doing that. So let's talk about the third most common mistake that executors make and how to avoid them. And that's failing to comply with legal notice and other requirements. So remember earlier I said probate is pretty simple in Pennsylvania. And that is true, and there's a lot of things that you can opt out of, but there's some things you can't opt out of, and there are some things that add a bit of complexity, right? So there's all these legal requirements, and you as the executor are in charge of that, right? For example, once we now probate this will, we've got to give everyone in the will notice, right? I tend to give a copy of the will too, but you could just let them know that it's on record at the courthouse. The reason I like to give it out to the beneficiaries is because I want to let them know that we're starting off in a cooperative standpoint with the beneficiaries. Once we probate a will, it is public record, so anyone has the ability to get that. The rules are slightly different when it comes to a revocable trust. And once we've given out that notice, we also have to certify then to the court that we've done this. Okay, well that sounds simple enough. So what's so tricky about this, right? Giving notice. Well, in addition to giving notice to those who are named in the will, you've got to give notice to the intestate heirs of the estate and anyone who has been disinherited, right? So who are the intestate heirs? Well, I don't know, right? The laws of Pennsylvania tell us who those people are. And that's under the Pennsylvania's Estates and Fiduciaries Code. But you've got to give them notice, right? And if you don't give them notice, you give out all the money, and then these people crop up, you're going to be personally liable for what you did or you didn't do. So you've got to be really careful that the right people get notice, that the court gets certification of those notice, and that you comply with all the other probate requirements of the estate administration. Now, an estate administration can take anywhere from 1 to 3 years. And during that lengthy process, the court wants to make sure that the probate requirements are being completed. So you have to send the court status reports that lets them know what you've done, what you haven't done, and what still needs to be done. So mistake number 3 is the failure to comply with legal notice and other requirements. Right? So then we're going to move on to the fourth most common mistake executors make and how to avoid them, which is making early distributions without protecting yourself. So the next, and I think I've got these slides just a little bit off here. Hold on. Looks like we might be missing a slide, but that's okay. So the next one that we're going to talk about, and let's recap, right? The first most common mistake executors make is probating the wrong documents. Then we want to make sure that we don't make early distributions without protecting ourselves. Next, we want to make sure that we comply with legal notice and other requirements. So the next fourth most common mistake is the failure to follow the terms of the will, right? Again, this sounds really simple, right? But I can't tell you how many times people come to me and they've done everything they're supposed to do and they probate the correct will and they do the notices and the probate requirements, but they didn't follow what the will said, either because they were inattentive or they misread it or misinterpreted what it said, or they just plain made a mistake. For an example, specific bequests need to be paid out first and within a certain time period. What if that doesn't happen? What if there's a math formula and you've got the math wrong? I can't tell you over the years how many banks or trust companies have reached out to me because they may or may not have complied with a formula clause correctly or incorrectly. So it can be awfully complicated. So as an executor, you've got to review the will. You've got to create a checklist for yourself. You've got to hire an attorney who's going to help you understand what the will says. And sometimes it's even advisable to go to court to get clarity as to what it says, or you could be held accountable, right? I've seen wills that say all sorts of things, and sometimes we need clarification to make sure everyone is on the same page. So here's an example of an estate administration where it would be tricky for the executor to follow the terms of the will. I had an estate administration, and I had a specific bequest of $1 million to a specific charitable institution. But in parentheses, I had that charitable institution was going to receive $100,000. Well, what's the executor supposed to do, right? Which terms are they supposed to follow in the will? Should they give this charitable organization $1 million, or should they give the charitable organization $100,000? Well, I'm not sure, and that's why you need legal advice to help you come to that determination. Now, I told you before, I've been hired by trust companies and banks when we've got really complicated formula clauses that are hard to interpret. One of the things that I would say to this from a practitioner standpoint is, when you're drafting your last will and testament, I have clients who are Fortune 500 clients, who are famous people who want very specific things in their will. But if I can't understand what they want me to do, then that's not how it should be laid out in their will or their revocable trust. Because when they're gone, somebody needs to be able to understand what the terms of the will says. And if we get to a point where we're not quite sure, then we need to go into court, put everyone on notice, and try to figure out together what that term of the will says. So moving on to the fifth most common mistake that executors make and how to avoid them is failing to get an early payment discount for Pennsylvania inheritance tax. So let's stop right now and talk about all the taxes that are involved when someone passes away. When someone passes away, there's a state death tax in Pennsylvania. That's called the Pennsylvania inheritance tax. And that tax depends on who the asset goes to, what the tax is. So if I'm giving something to my spouse, it's at a 0% tax. If I'm giving something to my child, it's a 4.5% tax. And if I'm giving something to, let's say, my friend, it's a 15% tax. And it doesn't matter if you've got $1 or $10 million, it's all subject to tax. Now, there are some tricky caveats, as in life insurance is not taxable for state purposes, but it's taxable for federal purposes. But we don't really need to get into any of those nuances. So now we've talked about one tax, right? The state death tax, called the Pennsylvania inheritance tax. But there's actually the federal estate tax as well, which is called the Federal Estate Tax Return, also known as the 706. Right now, we have an $11.4 million exemption from that federal estate tax. That means if your estate has less than $11.4 million, you don't have to worry about that 40% tax. And if you have over that amount, you do have to worry about that estate tax. Now, it's important to understand, even if you have under that amount, you as the executor may gather the assets and say, oh, good, we've only got $4 million in this estate, so we don't have to worry about filing a federal estate tax return. And that would be wrong. That would maybe even be my number 11th most common mistake executors make, which is there are certain things that you can still do. For an example, we've got something in the law called portability, where one spouse can port onto the other spouse their unused federal estate tax exemption. This is very, very helpful for wealthy families who may have more than $10 million but less than $22 million. And as the laws are ever changing, really important for even families with just a few $1,000,000. So there might still be a reason to file that federal estate tax return, even if we have under those amount of assets. Now, the next tax returns we're going to talk about is personal income tax returns. You, as the executor, are liable to make sure that the state and the federal death taxes are filed within 9 months after someone passes away. You can get a 6-month extension, but that extension does not absolve the liability of paying the tax, and interest and penalties can be accruing. So besides that is the personal income tax. You've got to file that final income tax return for the person who passed away, and on top of that, you've got to file an estate or trust income tax return that's going to take all the income or all the expenses that have happened from the time that person passed away to the end of the estate administration and when you give out those final proceeds 1 to 3 years later. Someone's got to file those tax returns. So what we're talking about here is making an early payment of that first tax, that state death tax. If you make a prepayment of the tax within the first 3 months after someone passes away, you get a 5% discount. So really that's like getting a 10% return over the year. So it's a really good idea to make that prepayment. But the caveat here is, I don't know if you have friends or family members, when they see a sale or a coupon, they've just got to do it or they've got to buy it, right? So sometimes we've got to think about this a little bit and say, we should only do this if it really makes sense. I have certainly had estate administrations where we've got tens of millions of dollars, but we have no liquidity. If we have no liquidity, it doesn't make sense to make that prepayment, right? So we've got to think it through before we actually make that payment. But it's one of those things that the executors oftentimes, we're going to talk about some other mistakes executors make. But oftentimes when I see executors and they haven't hired counsel and now they're coming to me, looking to me for advice, this is one of the things they haven't done. Another thing that they normally haven't done is if they probate the documents, they don't often pay the right amount of probate fees. And in Pennsylvania, if you actually overpay probate fees, they don't give them back to you. So that can be really important. Again, from an executor's perspective, you're personally liable for those mistakes that you've made. Are the beneficiaries going to ask you to pay the estate back that money that you just lost the estate, or that money that you paid out that you didn't need to pay out? I don't know. That's why we want to make sure that when you make a payment for things, it's the correct amount, right? So we've gotten all the way up to number 5. So let's go back and look at what we've talked about, right? The 10 most common mistakes executors make and how to avoid them. We want to make sure that we probate the correct documents and we only probate if it's necessary. Then we want to make sure, number 2, that if we're going to make early distributions, we need to make sure that we protect ourselves and we do it in the smartest way possible. Then 3, we want to make sure we comply with legal notice and other probate requirements, because you as the executor are liable to make sure those things happen and they happen correctly. Then the 4th most common mistake is the failure to follow the terms of the will, right? We can have ambiguous terms. We can have complicated formulas. We can have lots of things that we're not quite sure what has happened or what hasn't happened. I can't tell you how many estate administrations I've had when I have a family come in to see me after the death of the second spouse, and they show me their will or the revocable trust for their parents. And here they had trusts underneath their wills that had to be created at the death of the first of them, and they never did it. Well, what if there's ramifications to them not doing it, and you as the daughter were the executor through this process? Are your siblings going to sue you for that difference of could be hundreds of thousands of dollars of tax liability? Well, we want to make sure that that doesn't happen, and we follow the terms of the will. We actually read it. We look at it. We think about it. We get legal advice as to what it says. And then the fifth most common mistake is the failure to get this early payment, this early discount for Pennsylvania inheritance tax, right? Not always mandatory that we should do this, but really important to know that deadline and decide whether or not we want to make that payment. So we're going to move on, and I'm just looking right now to see if I've got any questions. Maybe take a pause. If anyone has any questions about the first 5 most common mistakes executors make, or what an executor is, or what an estate administration is. I'm going to keep moving, but as I see questions, I'll either add them into what I'm saying, or if I think it's a particularly poignant question, I'll explain that question to the group. So we're moving on to the 6th most common mistake that executors make and how to avoid them, which is the failure to coordinate with professional advisors, right? How do I get that A team? Well, who do I need to help me? So the first person that you're going to need to help you is a lawyer, right? So we're going to go and we're going to meet with a lawyer. Oftentimes it's the lawyer who's drafted the will, and we're going to sit down and we're going to talk about the estate administration. For what I do for clients is that initial consultation is free. We talk through all the requirements in an estate administration and decide who's going to do what, and based on that, I can let a client know exactly what a flat fee is for the estate administration services. And that can be really helpful. But if you go to, let's say, a lawyer who doesn't charge a flat fee and has a billable rate, the question you want to ask is not what is your billable rate, but what are the services that you're going to provide for me for that amount. Remember, somebody with a high billable rate, they might have systems in place and document preparation systems and paralegals who have been doing this for a long time to offset some of those costs, and it might make sense to still go to them. One of the things I often tell my clients is, this is a long process, and estate administration takes anywhere between 1 to 3 years. So we want to make sure that we've got the right people in place. So when I meet with family members, I say, we're going to meet over the next year to 3 years together. If this isn't the right fit for us, we should seek different counsel. I have certainly said no over the years to doing estate administrations where I didn't feel like it was the right fit and moved them on to a different law firm who I thought was a better fit for them. But it's really important to get the right people in place to help. One of the other things that I do to offset a little bit of the cost that you're going to pay for an estate administration is getting an accountant involved right from the beginning. Getting that accountant to do the final income tax returns for the person, doing the final estate income tax returns. I had a client recently reach out to me and say they bought the most sophisticated TurboTax program, and it allows you to do these estate income tax returns now. And I said, TurboTax can be a really great thing, but for something like an estate income tax return that coincides with a federal estate tax return, and there could be things that you put on one or things that you put on the other, is probably not the best place to do it on TurboTax. It really should be done with legal assistance and an accountant who's involved right from the beginning to make the best decisions possible for this estate, right? Because we want to save the estate as much money as we possibly can and give the beneficiaries as much money as possible. Now remember, you as the executor can be paid for your services. So we'll want to talk about that as well. Sometimes it makes sense to take a fee. Sometimes it doesn't make sense to take a fee. So we'll want to think about that. So we want to make sure that if you are getting a flat fee, that you know what all is entailed in that flat fee. And then remember, all of these fees for the estate administration, they're going to be deducted off the tax returns. So it's really like you're only paying us half of what you're actually paying us. And then if you divide that out between the beneficiaries, let's say you pay me $5,000 for an estate administration. Really, in effect, it's like paying me $2,500 and spread between, let's say, even two beneficiaries. A little bit more than $1,000 per beneficiary is certainly worth it to make sure that you're protected and everything that's supposed to happen in an estate administration happens, right? So on your A team, we want an executor. One, from a beginning standpoint, you want to put somebody in the document that you trust will be able to handle these kind of obligations and reach out and get the kind of support they need. So of course we could have a corporate executor or a family executor, and there's certainly benefits and consequences to both. A corporate executor, someone like myself, knows exactly what's supposed to happen and can do it. Whereas if we have a family member, they might not know what they need to do and wind up mucking things up, right? But at the same time, your family executor knows your family. And if, let's say we've got minor children and we're funding minors' trust, it might be great to have that family member get to weigh in on what's happening in the estate administration, where a corporate executor isn't going to have that familiar availability, right? They probably don't know them. And then from a cost perspective, of course, a corporate executor may cost more than a family executor, but both are able to take fees, right? So that's the 6 most common mistake executors make. So let's move on to number 7, right? So first, let me tell you a little bit. I've been reading this book. One of my clients wrote about how people die, and I found out that Beethoven, as amazing as he was, wrote his will on his deathbed only 3 days before he died. So in the many years that I've been practicing estate work, I have done a few of these deathbed wills and some updates to wills, but it's not what I really want to have happen, and it's not what the family wants to have happen. It is absolutely fraught with danger, right? Does the person changing or making this really have capacity? Are they with it enough to do it? Is this really what they want to have happen? And should they really be worrying about this at the very end stages of their life? Or should they spend that time with their family and loved ones and not necessarily me, an attorney, right? Another reason not to do this is we don't all know when we're not going to be here anymore. So it's really important to have these things set up ahead of time so that your family doesn't have more things that they have to deal with besides the loss of a family member. Now I'm going to give you a real-world example right now. I had an estate administration actually in my own family where a distant relative changed his will pretty drastically a day before he passed away. And he left a large inheritance instead of to family, to a friend. Well, did he want to do that one day before he died? Do you think he wanted to make that change or not? Well, none of us may ever know that answer, but of course, this matter had to be litigated, right? The family's upset and says this isn't really what he wanted. Somebody tricked him one day before he passed away while he's not in his right mind, and some unscrupulous attorney was willing to make this change. Or did he have all his wits about him and really want to make this change and want all his assets to go to his friends? We don't want that ever to be the case for any of us or our family members and friends. We want to have these documents in place well before we need those documents so that we are sure that the right document, just like we talked about in the first most common mistake, the right document is probated. So now we're going to talk about the 7th most common mistake, and that's the failure to advertise the estate. Many of you have seen these little ads in your local newspaper, or if anyone has read the local law reporter, which I hope none of you do that, but if you do, you'd see that these ads say that such and such law firm has been appointed to represent the estate, and this person is the executor, right? It's important to put creditors on notice. So some clients say to me, really, we should put creditors on notice? It's like waving a red flag in front of a bull. But this is really important for you as the executor, because if you don't advertise the estate, you hand out all the money, and then a creditor claim crops up 2 years later and is a valid claim, you're going to be responsible for making that payment. Do you want to make that $30,000 credit card payment after you've given all the money out to other people who may or may not want to give you that money back? My answer would be no. And if you advertise the estate 1 year after the last advertisement, it cuts off all creditor claims. So here in Pennsylvania, depending on the particular claim, we've got a statute of limitations, which allows those creditors to come back from anywhere from 2 to 4 to 6 years. This cuts that down to 1 year. So after the estate administration is complete, you now no longer need to worry about anyone coming back to you to get money from, right? I've certainly had this happen in estate administrations, actually time and time again, where we advertise the estate administration, and 1.5 years or almost 2 years later, we get a claim, some creditor's claim. Some of them are dubious claims, and some of them are legitimate claims. But once we let them know we've done this advertisement and we send this documentation, they politely remove the claim that they've got against the estate, and they go away. That's exactly what you, and as an executor, want to have happen, right? It only costs a few $100s, but it limits your liability for a certain amount of time, and it's going to give you that comfort in knowing that after that year, you don't have to look behind your shoulders anymore, right? So now we'll move on to the 8th most common mistake that executors make and how to avoid them, right? And that's getting help too late in this process. So if you've never been an executor, you might think it seems like a pretty simple process. I would assume that most of the people on the phone here, and now that you've spent some time listening to all these things that an executor can do wrong, you'd understand that it's not as simple as it appears, right? So sometimes people, they're appointed as the executor. They go and meet with an attorney. They hear a big number for the attorney fees, and they think, you know what, I can do this myself. And what happens is they go through this estate administration, normally mucking things up left and right, and then eventually have to come and see me. And what I can say is, in the many, many times this has happened, the estate actually ends up paying me more money and winds up having the estate involved in some form of litigation because they didn't get help early enough, right? So it's really important to make sure that we get that help that we need from the very beginning, right? Just remember, like we've been talking about this as a role, right, as a fiduciary obligation, because the executor has this fiduciary responsibility to take care of these funds while they're in their stead. But we haven't really talked about the emotional component, which is somebody has just passed away. And if you've been appointed as the executor, it's probably a family member or a friend or someone that you loved quite a bit. And there's a lot of emotions that are going on with that. So one of the ways to deal with that is by giving some of that legal work to someone else so that you can then deal with the emotional ramifications of that person passing away, right? So it's really important. We know that old saying, right? Don't be penny wise and a pound foolish. Make sure we get the help that we need, right? We've got to get that help because an estate administration can be time consuming. It can be really complicated. And of course, it's going to be emotional. And it's really important to understand that you've got this personal liability throughout this estate administration process. Now, we haven't talked about the prudent investor rule, but that's really important because you have a fiduciary obligation to the estate to manage the funds as a prudent investor would, right? So what does that mean? That's something that I sit down with my executors and we talk about. Are we keeping the assets invested in the way that they were previously? What if we have an estate administration? And I've certainly had this with lots of varying kinds of stocks, but what if we have an estate that's got $10 million worth of Exelon stock? Well, according to that prudent investor rule, what should we do? So this is something else an executor has to be aware of. You can't just take the money and give it out to other people and complete these requirements. You've got to make sure you're handling the money the way that you're supposed to, whether it's cashing out these investments and putting it in a low-risk portfolio, whether it's cashing it and putting it in a savings account, whether you put it in one bank account or multiple bank accounts, because the FDIC is only insured up to $250,000. All of these things are things that you have to be careful of throughout this process. So it's really important to get that help from the very beginning, right? So let's start back at the beginning, right? Let's look back at what we've talked about. The 10 most common mistakes executors make. We want to make sure that we probate the correct documents, and that when we probate, we are probating the amount that we're supposed to, and we're probating maybe even if we don't have to. We want to make sure if we're going to go through this process that it's really required to do it. And the second mistake, we want to make sure that when we pay any of this money out, a small amount, a large amount, all of it, we want to make sure that you're protecting yourself when you make those distributions, right? With something like a refunding agreement or a receipt, release, and indemnity agreement. Then the third mistake, we want to make sure we comply with legal notice and other probate requirements. And sometimes these requirements seem very simple, like giving notice to the people named in a will. Sounds really simple. But we fleshed that out together and said, wait a minute, the law actually says, and also to the intestate heirs. Now I need to figure out who are the intestate heirs. Are they different than the people named in the will? And is there anyone else I need to give notice to? And then I've got to let the court know that. And I've got to let the court know what's going on through this process, right? And then we get to the fourth most common mistake, which is the failure to follow the terms of the will. Again, it sounds really simple, but it doesn't always appear that way. Right now, when I do a will, they can be anywhere from 20 to 75 pages long. So it can be really complicated to understand what's going on in this document. And it's a really good idea to get a checklist, to get some legal advice, to figure out what is happening in this document so that you make sure that you do everything you're supposed to. I've had estate administrations. I do it very infrequently, but every once in a while I have an insolvent estate administration. Sometimes it's because we hold many millions of dollars separately in a trust and we have very little in the estate. Sometimes it's just that there's very little money in the estate, right? Well, I've had clients come to me after they've probated the estate, tried to pay some of the creditors, and then given a little bit of money to the beneficiaries, and found out that even though that's what the will said to give it to these people, the state's code says that if there's not enough money to pay all the creditors, it has to be paid in a particular order. And what if they didn't do that? They paid some of the creditors, but not the other creditors. Well, again, this is where in comes that personal liability. This executor is now personally liable for the mistakes that they've just made, and all they thought they were doing was the right thing, which is paying the bills and giving the money out to the beneficiaries, right? Then we get to the fifth most common mistake, and that's the failure to get the early payment discount for inheritance tax purposes, right? We've talked about that there's, unfortunately, like Benjamin Franklin said, death and taxes are certain, right? There are lots of taxes involved when someone passes away. So we just want to make sure we're completing all those requirements in the time frame that they're allowed to be completed, and that we're taking advantage of any prepayments. The sixth most common mistake, the failure to coordinate with your professional advisors, right? Getting that A-team. It's really important that you get the right attorney, the right accountant, and you all work together as a team, the A-team. So in my estate administrations, from the very beginning, I reach out to the accountant so that we're on the same page throughout this process, right? Then the seventh most common mistake is the failure to advertise the estate administration, right? We've got to cut off those creditor claims so that you're not personally liable for any creditor claims many years after you distribute the assets in the estate administration. Remember, your job as an executor is fraught with personal liability, so you've got to do all the things that you possibly can to limit that liability. And the eighth most common mistakes that executors make is getting help too late in the process, right? Sometimes we see that big bill, or we go to a law firm and think, I could save the estate some money. I'll just do it all myself. Remember to make sure that you're doing all the things that you're supposed to do, and don't wait until halfway through when you've already mucked up a bunch of things, because it's going to wind up costing the estate and maybe even you some personal liability if you don't get help right from the beginning. And then moving on to the ninth most common mistake executors make, and that's the failure to meet deadlines, right? We've now talked about an awful lot of tax returns. We've got the state death tax return, the inheritance tax return. We've got the estate tax return, that's the federal estate tax return. We've got income tax returns that can be filed on calendar or fiscal years. We've even got things like a deadline of a specific bequest. It has to be paid out in a certain amount of time. When we've got charitable beneficiaries, we've got to reach out to the Attorney General. We've got to work with the Attorney General's office when we've got charitable interests. We've got to remember to do that. And sometimes you might say, okay, I've got these things right here on this screen. I'll just write inheritance tax, 9-month deadline. Estate tax, 9-month deadline. Income tax, well, that probably has to be filed by like April 15th or something is what I remember. And specific bequests, make sure I pay them out. But it's not that simple, right? There are lots of things that we have to think about for these tax returns, right? We've talked about them a little bit. One, we want to make sure that the estate doesn't get audited. So when we file these tax returns, we want to make sure we're including all the information that they need. And so one of these goes with this failure to meet deadlines is, well, what do we put on the tax returns? What values do we use for the assets? Do we use the date of death valuation, or do we use an alternative valuation? Well, I don't know. We need an attorney and accountant to think about it and decide which we want to use, right? And then we've got to make lots of elections. We've talked about portability. If we don't elect portability on a timely filed tax return, you no longer have that benefit. It's gone, right? You can't say 3 years later, oops, I really should have done that. We actually have well over the federal estate tax exemption, and now we could use that amount. Well, the answer is going to be no, and the beneficiaries are probably going to sue you for many millions of dollars because they're now paying a 40% tax on $11 million. Now remember, in 2025, that law is actually changing, and that exemption is going way back down to only $5 million. So it's really important between now and then, when someone passes away, to really think about whether or not we want to elect portability. There's other elections that can be made, though, as well. There's something called the generation skipping transfer tax. We're not going to talk about that. We could do a whole webinar on that alone. But it's really important to understand, if we don't make that election at a certain time, we lose that exemption. And again, that's a 40% tax. So these are pretty big ramifications if we miss something. And then there's simple things, which are between the estate tax and the income tax return, we can only take expenses on one side. Well, which side do we take it on? Where are we paying more tax and at what interest rate, right? Do we file this estate tax on estate income tax return on a fiscal or on a calendar year? And then there's things that coincide between the final income tax return and the estate income tax returns. Like if we have something like E-bonds in the estate, we could cash them in fairly quickly and put them on the final estate income tax, final personal income tax return, or the estate income tax return. So it's really important to spend that time strategically thinking about what we're doing in the estate administration regarding these tax returns, the elections that we're able to make, and making them by the deadline, right? So that's the 9th most common mistake that executors make. So I'm going to pause here for a second. I told you a little bit about Beethoven passing away and doing his will just a few days before he passed away. But in this book that I got from a client who wrote a book about death, I wanted to tell you about another interesting death story, which I know you all probably know Houdini, right? He's a great musician. He's a great magician. He told a man, and that man just happened to be an amateur boxer. I don't think Houdini knew it, that he could withstand the heaviest punch to his midriff. He totally withstood the punch. He's a pretty amazing man. But a few days later, he died of ruptures in his abdomen. And coincidentally, his wife, Beth, she was in the hospital at the same time in a separate room recovering from food poisoning. He was buried in the bronze casket he used for his buried alive stunt, which is pretty interesting. And while he was dying, he told his wife he would send her a secret message from beyond the veil. But she never received that message or before she passed away, or not to any of our knowledge. So a little bit of interesting trivia for you. You know that Beethoven waited to the last second to do his will, and that Houdini maybe shouldn't have told somebody, and maybe this is good advice for you, not a 10 most common mistake, but just good commonsensical advice. Don't let someone hit you really hard in the midriff, and if it hurts afterwards, see a doctor right away, right? So let's get to the last most common mistake that executors make and how to avoid them. And that's the failure to properly close the estate administration. So there's a couple of different ways that we can conclude an estate administration. We can do an informal accounting through all the beneficiaries, or we can go through a formal accounting through the court system and have a judge stamp off on everything that you did in the estate administration. Now, most of the time in my estate administrations, I don't have to fully go through that court accounting, right? We can have something called a family settlement agreement or informal accounting where we lay out the assets in the estate, the expenses in the estate, the amount that the beneficiaries are receiving, and everyone signs off that they're absolving the executor of liability and that they'll refund any amounts that you inadvertently gave out to them. So that is really, really important. Really important because it can be things as simple as maybe your brother didn't know that you sold the house for $400,000 and he thinks you could have sold it for $500,000 and he's angry. We want to let him know before the estate finishes that we sold it for this and we want him to agree to it. Now, sometimes I do have to go to court because we either have a family in disagreement, or sometimes when I have a big institution like a trust or a bank, or if I'm working with the Attorney General's office, we want a judge to sign off on something so that it can thoroughly absolve the personal liability of that executor. So this 10th most common mistake is the failure to properly close the estate. Give out the money before we've had everybody sign off on this final family settlement agreement, or we've gone through the formal court accounting process. So those are the 10 most common mistakes that executors make and how to avoid them. So I wanted to give out, for anyone who hasn't fallen asleep on this call, I'm looking right now at this GoToWebinar chat box and where these questions are, and I've got a prize, a $50 Amazon gift card for the first person to write into this GoToWebinar chat the answer that you may just know, but I just read about in my client's book on, give me the answer to how Alexander Hamilton died and by whom. I'll wait to see if I get that answer. If I don't, I'll ask another question. All of you are pretty close to the internet. You could probably find that out pretty quick. Good, and we've already got an answer. Well, wonderful. Well, we keep track of who that person is, and I look forward to giving you that $50 Amazon gift card. So let's move on. We've got a couple of minutes left here. Feel free to ask any questions, but we're going to talk about some questions that I've already sort of prepared for you, which is, should you have a will or trust? What's a self-proving will, and who should I name as executor? Now remember, all of these things could have their own webinar, right? Have their own webinar. And actually, I'm going to pause right there, and I'm going to look back at some of these other questions. I think I talked through a lot of those questions, but let's see if there's any of the questions that I didn't answer as I was going through it. So we've got a great question, the legal notice. What is the legal notice required? Remember, it's a legal notice that's required in the local county in which the person passed away, in some local circulation, and we also have that notice in the legal reporter of that town. Which state applies? Oh, this is a really good question, right? When someone passes away, I get this question all the time. I'm a beneficiary and I live in Florida and the person passed away in Pennsylvania. Do I owe tax? The tax, the state and the federal tax are all dependent on where the person resided at the time they passed away. And sometimes that answer, I've actually had to go to court for that and litigate this matter where somebody was living, whether they were living in Pennsylvania or in Florida. And this just means we need to look at the death certificate, and where that person died is where they're going to owe state death taxes, right? So remember, insuring an estate against any liabilities, you as the executor, we talked about this a little bit with this prudent investor rule, but you need to make sure as the executor, once you probate this estate, you've got to make sure that you've got homeowner's insurance, you've got to make sure you've got car insurance. You need to make sure that you have these things, because if the person passed away and the policy lapses, or the company says this person passed away and you needed to tell us, and now that insurance policy lapses, and let's say, like I've had in estate administrations, there's a fire that burns down the house. Who do you think is going to be liable if you as the executor let that insurance lapse? So that's really important to make sure of sort of right at the outset. And it's very possible that you could be appointed as executor and not know it, right? Because clients name it in their last will and testament, and sometimes they don't tell the person that they've named that they're in those documents. Normally what will happen is when someone passes away and the documents are located, you would be reached out to. You don't have to act. I have a situation right now where someone who didn't want to act as the executor, you don't have to just because you're named in the document. You can certainly renounce in favor of someone else. There could be a mechanism in the will that does that, and if there isn't, there's defaults in the law, right? So one of these bonus questions, we only have a couple more minutes, is should I have a will or a trust? And the quick answer to that is in Pennsylvania, most times a will is just fine. A revocable trust can be really helpful if we've got a very large estate, if we're disinheriting someone because it's a little bit harder to challenge. Sometimes when we have someone very elderly, we'll put things in a revocable trust so those assets stay a little bit more protected. But because Pennsylvania's probate fees are so inexpensive, it oftentimes makes sense and saves you as a consumer a little bit of money to do a will versus revocable trust, which would cost a little bit more. And then a self-proving will, just remember, if you do a will on your own or by, let's say, a general practitioner, you want to make sure you've got a self-proving or attestation page, because if you don't have that on the will, you've got to find the witnesses of the will, you've got to take them to court, and they have to attest to being there and signing as a witness for that will very, very many years later. And oftentimes we can't find those people, and it slows the estate administration down, right? And then we've also talked about this, who should we name as executor? You could have a family member, a child, a parent. You could have a friend. We could have a corporate executor like a lawyer, a bank, or a trust company. We can have any of those variations, right? And I'm just looking at some additional questions. Got a bunch here. I think I've answered most of them, but anything I haven't answered, feel free to reach back out to me afterwards. So the difference between a revocable and an irrevocable trust, I'm going to give you the quick answer. which is a revocable trust can be changed at any time. An irrevocable trust remains unchangeable forever. Now, I'd say forever, but not necessarily forever. So we get to the last part. Besides this bonus, I wanted to give you guys an executor checklist, because maybe you listened intently to this whole webinar, or maybe you didn't, but it's really great to have a checklist if you are an executor or you're appointing someone as an executor, to just remind them of the basic duties that they've got. So you can look right here, and they'll be available for you after this webinar. We've got about 22 things that are just important to remind you as an executor, or you giving somebody that role. These are kind of the things that need to happen. There's a bunch of stuff, and they're time sensitive, so make sure you take care of them. So we've come to the end of this program. I want to thank you for joining me on this webinar. I hope you found this information beneficial. The slides and the link to the recording, they're going to be circulated shortly, so keep your eye out for that email. You can always access all our previous webinars on our YouTube page. It's Cohen Seglias. Of course, feel free to contact us with any questions about the topics that we covered here today, or any other issue that you have. And I'm going to leave you in the words of Robert Louis Stevenson. He was a great poet, and this is a poem he wrote, which is inscribed on his gravestone. Under the wide and starry sky, dig the grave and let me lie. Glad did I live and gladly die, and I laid me down with a will. This be the verse you grave for me, here he lies where he longed to be. Home is the sailor, home from sea, and the hunter, home from the hill. Thanks, everyone. Have a great rest of your day.